When you're buying or selling a home with Top Hat Connections, we'll already have gone over the contract in our consultation. However, I find that sometimes you're not absorbing all of the information, so it's good to have a refresher in those times of concern or if you just had a quick question. So hopefully this video will have all the answers you need with regards to the real estate sales contract of Oklahoma. The offer. Negotiations to purchase a home begin when the buyer makes a written offer to purchase the seller's home. The seller may accept, reject, or make a counteroffer to the buyer's offer. The offer may go back and forth until both parties have agreed to the terms in writing, and the document has been delivered to both the buyer and seller for signatures. At this point, the offer becomes a contract. During the offer and counteroffer process, the listing broker is required by law to continue presenting all offers to the seller up until the time the seller accepts an offer in writing. Furthermore, during the offer and counteroffer process, the seller may withdraw the seller's counteroffer and accept another contract if the seller's counteroffer has not yet been accepted and signed by the buyer and delivered back to the seller's broker. Likewise, the buyer may withdraw the buyer's offer and purchase a different property if the buyer's offer has not yet been accepted and signed by the seller and delivered back to the buyer's broker. All items of the contract are negotiable between the buyer and the seller. Prior to the buyer submitting an offer, the buyer should obtain a conventional loan available from a valid lending institution. This will assist the buyer to determine the buyer's housing price range. It is not a guarantee that a loan will be given. However, it does check the buyer's creditworthiness and known history. A buyer or seller should not confuse this with final loan commitment that cannot be obtained until just prior to closing to ensure that all of the buyer's financials are considered. The contract. This consists of the contract form and any related addenda or attachments. Once signed by both the buyer and the seller, the contract is valid and binding upon each party. Each party, both the buyer and the seller, should read the entire contract and related addenda and attachments. The contract must be executed by original signatures of the parties or by signatures as reflected on separate identical contract counterparts. The legal description section should contain the legal and physical property address. The contract, unless altered, shall include all fixtures and improvements and all appurtenances, subject to existing zoning ordinances or plat or deed restrictions. The utility easements serving the property, including all mineral rights owned by the seller unless expressly reserved by the seller in the contract, and excluding mineral rights previously reserved or conveyed. Collectively, we refer to all of these things as the property. Earnest money and source of funds. The earnest money is to be deposited in the trust account as noted in the contract immediately following a fully executed and delivered contract. The contract is designed for cash transactions unless a financing supplemental is attached. A home loan may be obtained from a mortgage company, credit union, or bank. It is the responsibility for the lending institution to disclose state and federal regulations regarding the terms and conditions of real estate loans for which the buyer applies. Should your contract be contingent on qualification of an FHA, VA, or conventional loan, then a financing supplemental will be attached to your contract. The supplemental will outline the responsibilities of the buyer and the lending institution with regards to the purchase of the property. Closing funding and possession. The buyer will be required to pay the balance of the purchase price with cash, cashier's check, wire transfer, or other funds acceptable to the seller. 9 times out of 10, it's going to be a wire transfer. The closing company, however, cannot accept certain forms of payment, such as a personal check, corporate check, employer's check, investment account check, or asset management checks. Most closing companies, though, will not accept cash because they are not designed or equipped to do so. It is recommended that the buyer contact the closing company prior to the closing to determine the acceptable form of payment for the balance of the purchase price. The buyer will need to present government-issued identification, for example, a driver's license, at closing. Proceeds to the seller from the closing are generally paid by the closing company's check or a wire transfer. Accessories, equipment, and systems. This section of the contract lists items that will remain with the property. If there are additional items the buyer wants to include, the items should be specifically listed under additional inclusions. The seller is bound only by what is stated in the contract, and the buyer should not rely on anything other than what is written in the contract. That is very important. If the seller is not including an item in the purchase price, the item or items should be specifically listed under exclusions in the contract. The residential property condition disclosure requires the seller, unless exempt prior to the seller accepting an offer to purchase, to complete and make available to the buyer a residential property condition disclosure statement form or disclaimer form. The disclosure form requires that the seller disclose a vast amount of information regarding the property. The disclaimer form indicates that the seller has no knowledge regarding the condition of the property and has no actual knowledge of any defects and has never occupied the property. The real estate licensee, myself, has the duty to obtain the disclosure or disclaimer form and any amendments from the seller and provide them to the buyer prior to the seller accepting an offer to purchase. Now, as a realtor, it is my duty to disclose to the buyer any defects in the property actually known to me which are not included in the disclosure statement or in any amendments. However, I do not have a duty to conduct an independent inspection of the property and have no duty to verify the accuracy or completeness of the statements made by the seller. Both parties should read the Residential Property Condition Disclosure Act for more information. The publication can be found on the Oklahoma Real Estate Commission's website at oklahoma.gov/OREC. Investigations, inspections, and repairs. I always encourage the buyer to have a professional with appropriate qualifications conduct inspections of the entire property during the time period stated in the contract. The buyer should accompany the inspector during the inspection and should not rely on a friend or themselves to make these inspections. The contract language does make reference to a person that the buyer deems qualified, but the buyer should be aware that no one can receive compensation for performing an inspection unless they have obtained the appropriate license from the Construction Industries Board or other applicable state licensing board, commission, or department. The treatment, repairs, replacements, and reviews paragraph addresses what the buyer should do if the buyer, based on those inspections, determines that items need to be treated, repaired, or replaced due to them not being in normal working order. If the buyer and seller fail to negotiate the treatments, repair, and replacements items, and if a written agreement for the seller to complete all agreed treatments, repairs, and replacements prior to the closing date is not reached between the parties within the time stated in the contract will be terminated, and the earnest money deposit shall be returned back to the buyer. It's important to note that all expenses incurred by the buyer are not to be taken out of the earnest money deposit. Final walkthrough, risk of loss, and acceptance of property. The contract allows the buyer to inspect the treatments, repairs, and replacements made to the property, and the buyer may perform a final walkthrough regarding the overall condition of the property prior to closing. The buyer shall pay for any incurred costs for re-inspections unless prohibited by the mortgage lender. The risk of loss paragraph states that prior to transfer of title or transfer of possession, the risk of loss to the property shall be on the seller. After transfer of title or transfer of possession, the risk of loss is going to be on the buyer. The acceptance of property paragraph states that unless otherwise agreed to in writing, once the buyer accepts title or takes possession of the property, the buyer shall have accepted the property in its present condition. No warranties expressed or implied by the sellers, brokers, and or their associated licensees with reference to the condition of the property will be deemed to have survived the closing. Title evidence. This paragraph outlines the buyer's and the seller's expenses and time requirements for the parties. To accomplish this, the seller must make the abstract of title available to the title closing company so that the abstract can be brought up to date. The buyer, at their expense, may obtain a commitment for issuance of a title insurance policy or an attorney's title opinion, depending on whether the transaction was financed or not. If a title issue does arise, the seller is to make reasonable efforts to cure title defects that have been identified. This may cause a closing date to be extended, which is also referenced in the contract. Upon closing, any existing abstract or abstracts of title owned by the seller shall become the property of the buyer. Mediation. If a dispute arises regarding the contract, the dispute shall be submitted to an alternative dispute resolution system available in the county wherein the property was located. Any settlement agreement shall be binding. In the event that an agreement cannot be reached between the parties may pursue legal remedies as provided in the contract. Breach and failure to close. Both parties, the buyer and the seller, must understand that failure to act within a time period set forth in the contract shall constitute a breach of contract.